I have a history of working through a providing agency, but because you took that away from me, that's the only.
Oh, no, I don't know. Everybody knows I do not allow people to work as home health care providers when you're on probation for a felony. Everybody knows that.
She openly admitted to breaking the rules. She confessed to leaving the county without permission, but then she made a critical error. She told Judge Boyd she didn't see the problem. Facing the possibility of having her probation revoked for burglary, this defendant thought a sob story about a relative in need would somehow excuse her actions. She was mistaken. Pay attention as a time-served plea deal vanishes the moment the judge starts asking straightforward questions.
All right, court is calling 2023 CR 7787, State of Texas versus Anna Marie De La Rosa. Can I have parties announced for the record for the state?
State.
Defense?
Ray Lopez for the defense.
All right, and are you Miss De La Rosa?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Anna Marie De La Rosa who was placed on deferred adjudication in 2023 CR 7787 for the offense of burglary of a building with intent to commit theft on April 30th, 2024 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, the state wishes to proceed on violation of condition number 6. On or about the 10th day of July 2024, the defendant, Anna Marie De La Rosa, departed Bexar County without the written permission of the court and or supervision officer in violation of condition number 6.
How do you plead to that? True or not true?
True.
We waive and abandon all of this, Your Honor.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 6, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 6?
Yes.
Court will find violation of condition number 6 true. Is there a proposed agreement?
There is, Your Honor. It is for the state's motion, enter an adjudication of guilt against the defendant, revoke her community supervision, and sentence her to 232 days in the Bexar County Jail under Texas Penal Code 1244A.
All right. So why would I follow this agreement? Because I'm assuming that's a judgment satisfied.
It is, Your
All
Honor.
right. Why would I do that?
Your Honor, she's contesting the charges that she picked up in Medina County. She does admit, though, that she left the county without permission and remorseful for that. And is looking to put this matter behind her.
Oh, I'm not, just so everybody understands, I'm not considering anything else on the motion. I'm just considering violation of condition number 6. Has she done anything on probation? Has she completed anything? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Anna Marie De La Rosa.
All right, what have you done on probation?
I reported to probation. I've also been looking for work, like as said on my probation. I had work in line, but considering that I left,
Why did you leave the county?
I had to go and pick up my sister-in-law from where she was at because she got stranded. So that was.
Here comes the excuse. She left the jurisdiction without permission, claiming her family needed a ride. She insists she didn't think it was an issue. That's the very definition of entitlement. She believed her own schedule was more important than the court's orders.
Why don't you call probation and tell them, I need to go pick up my sister?
I mean, I didn't think it was an issue and a problem because I didn't think I was violating probation at that time. And she just needed a ride, so I went to go and get her. So I mean, I didn't see where there was a problem or an issue at that moment in time because it was just going and picking her up. And that was I didn't see that there was a problem.
Did you start on your parenting classes?
No, I have there was a parenting class that was in line for there.
No, my question is, did you start your parenting classes?
No, ma'am, I didn't.
All right.
But the reentry program does have those parenting classes, and so I just had to wait to get into that program.
Were you in felony drug court?
No, they said they denied me because I don't have no drug issues since 2017. My case wasn't related to drug issues.
And
I didn't
you're
come
not
in on no drug
employed.
charges or anything, so they drug court denied me because I have no drug.
Have you been
charges.
employed since April 30th, 2024?
Have I been employed?
Yes, since you've been on probation, have you ever had employment?
Well, my probation officer was supposed to check in with you because I have a history of working through a providing agency, but because you took that away from me.
Watch how she shifts gears when the judge asks a simple yes or no question. Did you get a job? Instead of a direct answer, we get a list of people to blame. She points fingers at the probation officer and the drug court. To Judge Boyd, this shows a clear lack of accountability.
Oh, no, I don't know. Everybody knows I do not allow people to work as home health care providers when you're on probation for a felony. Everybody knows that. So my question is, have you had employment since April 30th, 2024?
No, so I was looking for.
All right, so that's a no. Did you report to probation
I
since
did
April
I
30th of
did tell
2024?
yes, ma'am, I did. And I was also calling the hotline like it was told to do. I was doing my conditions as followed. Yes, I was.
Any other questions?
And I also called my probation officer to let her know where I was at. I tried contacting her several times and stuff. So I mean, I did everything that I was supposed to do. I do have job lines followed as well when I get out of here too.
But you haven't had an employment since April 30th, 2024. Any questions?
Ms. De La Rosa, did you complete your TAP evaluation? as
Yes.
ordered by the court?
Yes, ma'am. Everything was done.
When do you recall doing that?
When I was incarcerated in Bexar County. It was a top evaluation and then it was followed through drug court, which they denied me because like I said, they said because I don't have no drug history, there was no reason for me for them allowing me to take that course.
And then, so you were released from custody in June of 2024, does that sound right?
Yes, ma'am.
Okay, and then you were ordered to submit to drug testing in July of 2024. Do you recall that?
For the phone.
Yes.
Yes, and I was calling every day like I was told up until the time that I got placed into Medina County.
Okay.
And then I was there for 4.5 months.
So are you aware that your probation officer stated that you failed to submit to drug testing on July 12th, 19th, and 26th of 2024?
Because I was already incarcerated.
You were already incarcerated in July. And then are you aware that your probation officer is alleging that you struggled with calling the UA hotline as you were instructed to do?
If I wasn't incarcerated, how was I able to call the hotline?
So when were you incarcerated?
July 12th, 2024.
But before that, are you aware of any that your probation officer is alleging that you were having trouble, calling in on the UA hotline?
Because I was already incarcerated in July.
Before your incarceration?
There was no, I was calling every day. There shouldn't have been a reason why.
All right, any questions? Probation? What is probation's recommendation?
Judge, the court summary indicates they want revocation.
All right. Any objection to the court reviewing the court summary?
No.
The court is going to grant the motion, find you guilty. The court will revoke. The court will sentence you to 14 months in the state jail facility.
The deal is off the table. She was hoping for a light punishment, but instead, Judge Boyd is revoking her probation entirely. 14 months in a state jail facility. That's the steep price of disrespecting the system.
You're credit for any time served. There's to be no contact with Veronica Garza or 1803 Macaulay, McCauley, San Antonio, Texas 78224. And no contact with Jose Gutierrez. I'm sorry, with Grace Rocha and Jose Gutierrez and Raquel Puente. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, good luck to you.
Anna Marie DeLoza had a golden opportunity. She had a plea deal for just over 200 days, which likely would have meant walking out the door. All she needed to do was demonstrate that she took her probation seriously. But when you offer excuses instead of taking responsibility, and when you tell a judge you didn't think breaking the law was a problem, the court's mercy vanishes. Judge Boyd turned down the easy deal and imposed 14 months in state jail. A harsh wake-up call for someone who thought the rules didn't apply to them. What do you think? Was 14 months too severe for leaving the county to help a family member? Or was this the wake-up call she truly needed? Share your thoughts in the comments below.